Well, there's a very short issue over here because the Supreme Court is covering the CBI is now investigating the bulk of what's happened in that very sorry incident of 9th August.
I think my friends have just served us a supplementary affidavit, my lords, late this morning. We'll need to read the affidavit and respond to it.
It's only an amendment of a prayer. And
we don't know all of these things, my lords, when it's served 20 minutes before.
Madam, the learned senior counsel Mr. Jetmalani mentioned that is, in fact, we sought for a clarification that when the Honorable Supreme Court is seized of the matter, whether this court can adjudicate this issue. Then learned senior advocate submitted that they have sought for clarification, and the Honorable Supreme Court was pleased to clarify that all other issues can be raised in the before the High Court. But as of now, the bunch of matters have gone out of the list, and we have said that liberty to mention as and when the matter as per the direction of the Honorable Supreme Court. So we want to be doubly sure that whether there is any order to that said effect, or it was an oral clarification.
My lords, the order is now out of the Honorable Supreme Court. It does not specifically speak to Mr. Jetmalani's petition in any which way, my lords. Though Mr. Jetmalani has an IA pending there in the Supreme Court and his 2 writ petitions here, and now a new supplementary affidavit which he's moved about half an hour ago and served all of us. This is the situation, my lords.
So that we can grant time.
Yes.
In fact, when you mentioned, we requested the counsel on record for the senior counsel to inform your good self.
Yes.
So that you
I'm so grateful, my lords. I'm so grateful.
You can be present.
Yes.
But, sir, one small request.
Yes.
Can that, some order in writing, if you can be able to obtain?
I asked the Supreme Court, I'll tell your lordship what happened. Ms. Guruswamy was present there, and the court pointed out that Ms. Guruswamy is present there, and the assumption being that she would tell your lordships what happened in court, but she's only revealed part of what happened. If I
That's not correct, my lords.
Ms. Guruswamy, you can reply to me. I regret you
this is misconstrued of what has happened. The court saw Mr. Jetmalani twice or thrice brought it to the notice of the court. The court heard him and moved on. This is what happens in these hearings, which are so proud.
All right, madam.
1 minute. Ms. Guruswamy, I'll take it. Please record what Ms. Guruswamy says. I'll tell your lordship about what happened. This is my view of the matter. The court said that Mr. Jetmalani, the only thing that we have transferred to the CBI is the investigation of the rape and murder and nothing else. And I don't think, and it said that the Calcutta High Court should be aware of the scope of what we have transferred. Ms. Guruswamy was there. And they point specifically told me Ms. Guruswamy is present in court today. That is in the Supreme Court. And I think impliedly it meant that Ms. Guruswamy would tell the court that this issue about the police commissioner of the state of West Bengal, of Calcutta, of the city of Calcutta, having revealed the name of the rape victim, was very much within your lordship's remit. They said that it's not necessary to. I asked them twice, why don't you all do it in writing? They said, Mr. Jetmalani, it's not necessary. And this is the point in paragraph 6 of the Supreme Court order. I will point out what the Supreme Court has said. The Supreme Court in paragraph 6 said, to answer Ms. Guruswamy's reticence, the CBI as it appears before this court, is conducting an investigation on 2 facets. That's all. The alleged rape and murder which took place on 9th August 24 at RG Kar Medical College and Hospital, and 2, the allegations in regard to financial irregularities which were also entrusted for investigation by the CBI by the orders of a division bench of the Calcutta High Court. There are only 2 issues very clearly specified. And my lord, I don't think we need any. This matter admits of no doubt whatsoever, notwithstanding Ms. Guruswamy's statement that Mr. Jetmalani mentioned it thrice. The court said there is no need to do this. Because
my lords, we are happy to appear before my lords. It would be a great honor to clarify this issue before my lords. All I'm saying is, since Mr. Jethmalani has dutifully served us late this morning with a supplementary affidavit, I didn't interrupt you, Mr. Jethmalani. Please don't interrupt me. Please don't interrupt me. Please don't interrupt me. My lords, all I'm saying is, we're just asking for some time to respond to these various supplementary affidavits that he keeps filing. This is all
I'm sorry. There are not various supplementary affidavits.
No, I mean there are two petitions here.
There's only one. There's only one amendment that has been made to a prayer.
I'll let him continue, my lords.
You let me continue.
Please go ahead. Please go ahead.
The commissioner of police.
Sorry for interruption.
Yes.
So the procedure here is
yes.
In the Calcutta High Court.
Yes, sir.
When you have to bring on record a document or something, a supplementary affidavit is filed and the document is annexed to it.
Yes.
And if there is an amendment of prayer in my parent High Court, they take out an application for amendment of prayer.
Yes.
Here they take out an application in IA CAN number so and so.
Yes.
For giving a supplementary affidavit. In the supplementary affidavit, there is a prayer. Please amend prayer A of my and so and so.
Yes.
So whenever it comes up, the dusty is there, that is advanced services required to be complied with.
Yes.
And court generally grants an opportunity to the other side to respond to whatever prayers they want.
No difficulty.
There are two things, sir.
Yes, sir.
One is whether the concerned commissioner, the then commissioner, who is implemented by name in this writ petition,
yes,
desires to file an affidavit.
Correct. That's for the state to tell us.
Because, madam,
I have to take instructions on it, my lord. I follow. I bow down. I appreciate what my lords are saying.
Yes, because he has to take a stand, a clear stand.
Certainly, I'll take instructions.
There are three respondents in the writ petition. The first is the then Commissioner of Police. The second is the Secretary Department of Home and Hill Affairs, State of West Bengal.
Yes, my lord.
Third is the Ministry of Home Affairs, Government of India.
My lord.
So the first respondent will have to file an affidavit.
Milord, I appear for the state, Milord, or the respondent number 2. But I also, Milord, wish to respond to whatever Mr. Jethmalani's client has filed.
Yes.
So I don't have a copy of the supplementary.
No. The learned Advocate General.
Yes,
a supplementary affidavit.
Yes, sir, I follow.
There are the allegations in the writ petition have to be answered.
Yes.
So the state can answer, the first respondent can answer,
yes,
and the government can also answer.
Yes, Milord.
Absolutely, madam.
If central government doesn't want to answer, doesn't want.
No, Milord, it is actually not belonging to the Home Department. It actually belongs to the Department of Personnel and Training. Because the IAS and IAS officers are all allied officers. They come under direct control of the Department of Personnel and Training. So we have to take instruction.
Madam,
we will commend your lordship to that effect. Your lordship may grant leave.
You have implemented the wrong respondent.
Your lordship, we will make the necessary amendments. In appellate side, it is permitted to amend through the advocate on leave granted by the Honourable High Court.
But then they have to be served. The department, the
your lordship, the learned ASG shall.
The ASG is a senior advocate, madam. So how you can serve?
I'll serve the Ministry of Law and Justice, your lordship.
Whatever is the procedure. And where is that supplementary affidavit?
Lordship, this is the supplementary affidavit.
But my instructions are, Milord, it has not yet been served on my learned junior.
Nice.
Who appears for state? I am appearing. You give one copy.
Sure.
What is it?
Sir, serve copy has been served. I'll serve.
Sir, there is one earlier order passed by the Honorable Supreme Court. I remember two orders. The first order, in fact, when we first passed the order in the bunch of petitions,
yes,
the lead case was the parents of the victim.
Yes, ma'am.
Where we had requested the electronic and print media that the identity or the name, etc., of the victim should not be disclosed.
Correct.
And we also said to YouTubers, etc., please be responsible in doing that.
Yes.
And we also masked the names of the writ petitioners. That is, the parents of the victims were shown as XXX.
Yes.
Subsequently, when the matter was dealt with by the Supreme Court, I don't remember the date of the order. The Honorable Supreme Court issued some directions to
Wikipedia, my lord.
Wikipedia.
Yes, ma'am.
Yes.
Direction.
That is one order we'd like to see.
Yes.
Then there is another order which says that it is not restricted only to Wikipedia but extended to so and so.
That's last time's order. That is the last order.
Last order date.
Your Lordship, I have placed that order. I've handed Your Lordship, last order I have handed over.
Paragraph 3 of the last order.
Lordship.
Order 2 and 3. Your Lordships may kindly see paragraphs 2 and 3 of that order. It is not confined to Wikipedia but shall apply to all intermediaries.
Yes, and the order prior to that was specific to Wikipedia.
That's right. For once we are in agreement with Mr.
Yes.
So therefore, sir, prima facie, the Honorable Supreme Court is also conscious of, seized of the matter regarding disclosure of the name of the victim by either print or electronic media or maybe individuals also.
Yes, sir.
There is another writ petition filed by, I forget his name.
Tipti Pandey and Apunna Banerjee. There are two writ petitions.
Two writ petitions have been filed. That also we have adjourned it along with the batch. Where one is regarding certain YouTube, not YouTube, WhatsApp.
Social media publication and displaying the photographs.
Photograph of the victim with very, very obnoxious statements.
And we have filed in 4% lawsuit direction.
And we directed the Joint Director CBI to see what can be done about it. Whether they can partner with the state cyber wing and do the investigation. But
my lord, in the last order, the Supreme Court had asked the Solicitor General through the Ministry of Electronics and Information Technology, this is paragraph 3, to nominate a nodal officer who shall in fact be the nodal officer to coordinate this, to deal with this unauthorized uploading of content of information pertaining to the deceased. That is paragraph 3. May I read paragraphs 2 and 3 out, my lords?
yes.
The earlier order of the court, so this is the last order of this court, shall, it is clarified, not be confined only to Wikipedia but shall also apply to all intermediaries. To reiterate, no intermediary shall allow or carry the publication of the name of the deceased, her identity, photographs or videos, either pertaining to the incident at the R.J. Kaur Medical College or otherwise. 3. On the request of the court, the Solicitor General has stated that the Ministry of Electronics and Information Technology shall nominate a nodal officer to whom any communication in relation to the unauthorized uploading of content or information pertaining to the deceased can be intimated so that necessary action can be taken with the intermediary concerned for pulling down such publication or dissemination. And then, my lords, paragraph 4 is the status report on the CBI investigation. Now, all we are saying, my lords, is given that the Supreme Court is cognizant of this facet of the case, and given that we have been served with these documents so late in the day, we are just requesting some time to respond to all of this. So
no difficulty, but I am not objecting to that.
No, Jethmalani is not opposing. But Madam, prima facie, on reading para 2 and 3,
my lord,
the Honorable Supreme Court is dealing with or issued directions not to do certain things, initially to one party, then extended to all intermediaries, then recording Solicitor General submission that how they can pull down this. But what about cases which are prior to this, where names were disclosed, identity, because 2 other writ petitions are running in the list.
Yes, my lords, I must also say with respect, these 2 writ petitions are identical to each other. They emanate from the same law office. I'll just bring that on record and I'll inform my lords. They are cut and paste copies of each other. The lawyers come from the same law chambers.
It is not new to us.
My lord, what does one say, my lord?
But you can be clear.
This is the state of public interest litigation.
Kindly may not remember the percentage lawsuit direction in Tipti Pandey's case, where they are disclosing and publishing photographs of the victims. We, pursuant to lawsuit direction, the joint director filed a report in seal cover.
That's it. Still in the seal.
Yes.
We have not opened the cover.
Yes, true.
But all I say is this, my lord. They make one final submission, my lord, and we can give time. I have no difficulty. I didn't know there was a new amendment made, but there's a new amendment and a new affidavit. Of course, he is entitled to take that. But the fact of the matter is, my lord, 9th of August, the Commissioner of Police, I'm saying alleged, is alleged to have made this disclosure on the 9th of August. We are now almost on 9th of October. Almost 2 months have passed. That something should be done. Nobody from the state
And this gentleman has since been transferred.
Again, with respect to you, Ms.
No, you keep calling him the Commissioner of Police.
I will give you
He's a decorated IPS officer. He has been transferred. He has gone back to the rank he enjoyed in 2021. He has gone back to that rank.
I don't know about his rank.
There is Article 311 of the Constitution, Mr. Jethmalani. I commend it for your reading.
No, I'm not on his status.
I commend you to please read
what I recommend to you, Ms. Guruswami,
sir, in page
2 of the new act, which is a criminal offence.
Page 68 page 68 of the state petition is a cover containing a compact disc, a CD.
Yes.
Whether that copy has been served on all of you?
No.
No, my lord.
I think that contains the recording.
That contains the police commissioner.
Yes. So that needs to be served.
Yes.
We don't have it.
What, Amrita? You have not served this?
That has not been served. I'll serve it today.
You have given it. We have not opened this cover.
Yes, my lords. We don't have this, my lords. Also, I am not privy to the amendment that bears either, my lords. I think these little
all right. The matter.
Matters. Yes.
The learned senior advocate, Mr. Mahesh Jethmalani, had mentioned this matter before this court for an early listing. So we had requested the learned counsel on record appearing for the writ petitioner to inform the learned advocates appearing for the respondents, including the learned senior advocate appearing for the first respondent. Accordingly, they have been informed that the matter is listed under the caption to be mentioned. The first clarification we wanted was whether this court can deal with the prayer sought for in the petition when the Honorable Supreme Court is seized of the matter relating to the RG car incident. It is a submission of the learned senior advocate appearing for the writ petitioner that a specific clarification was sought for from the Honorable Supreme Court, and it was and in the order passed to the Honorable Supreme Court dated
30th September.
30th September in paragraph 6, the facets, the two facets which were being dealt with by the CBI have been set down, namely 1I, the alleged rape and murder which took place on 9th August 2024 at RG Kar Medical College and Hospital, and 2Is, the allegations in regard to the financial irregularities which were also entrusted for investigation by CBI by the orders of a division bench of the Calcutta High Court. Therefore, it is a submission that the aspects dealt with by the Honorable Supreme Court are the above two aspects, and this court could be this court can consider the prayer sought for in the present writ petition.
My lords, I'm so sorry to interrupt. May I just say this one? I apologize for interruption. These two paragraphs pertains to the width of the CBI investigation. The Supreme Court is also seized of the doctors' agitation and national task forces set up. The facet of the Supreme Court's remit in this action is about
we are just recording the senior advocate submission, ma'am.
Yes.
We are coming to that.
Grateful. I'm so grateful.
To be noted, the learned advocate the learned advocate on record appearing for the first respondent has handed over to us a printout of the diary number 37351 of 2024 of the Honorable Supreme Court, and it is pointed out that two applications have been filed in IA number 216487 of 2024, which is an intervention application, and IA number 216488 of 2024, which is for clarification / direction, and both the interlocutory applications are still pending. The learned senior advocate appearing for the first respondent would submit that yesterday, late in the evening yesterday, a supplementary affidavit has been filed by the writ petitioner, and they require time to respond.
No, it was given to us today. This
Today morning, my lords. Today late morning. I in fact got it 20 minutes before the hearing, my lords.
Now, because
they wish to respond to the said prayer. As we note that the application for clarification is still pending, we have genuine doubt in our mind as to whether this court would be entitled to proceed with this matter independently, dehearse the matter, which independently, more particularly when the Honorable Supreme Court is seized of the matter. We say so because the Honorable Supreme Court has also issued certain directions with regard to the disclosure of the name and identity of the victim, which is evident from paragraph 2 and 3 of the order passed by the Honorable Supreme Court dated 30th September 2024. For better appreciation, the same is quoted here and below. Page 9 of the Honorable Supreme Court's order, paragraph 2 and 3. The above directions have been issued by the Honorable Supreme Court after having been apprised of the fact that the name and the identity of the victim is being disclosed by several intermediaries. The question would be as to the allegation made in this writ petition, which was prior to the orders passed by the Honorable Supreme Court, as well as prior to the order passed by the division bench of this court dated 13/8/2024. We give liberty to the respondents to file their affidavit in opposition not only to the allegations made in the writ petition, but also in the supplementary affidavit, as well as whether this court can independently proceed with the matter and consider the prayer sought for in the writ petition.
May I just say this, I'm sorry to interrupt you. That the allegation which we are seeking to canvass before we are seeking your lordship jurisdiction, invoking that jurisdiction, is the criminal aspect of the disclosure made. That's specifically it.
It is a submission of the learned senior advocate for the writ petitioner that what is being canvassed in the writ petition is the criminal aspect to the disclosure of the name and identity of the victim. So far as the offending material, which according to the petitioner, please write that out. According to the petitioner, the offending material has been placed before this court in the form of a compact disc, which is enclosed in a sealed cover in page 68 of the stay petition. We find the copy of this compact disc has not been served on the respondents. Therefore, there will be a direction to the learned advocate appearing for the petitioner to serve copy of the compact disc to the learned advocates appearing for the respondents during the course of this week. The learned additional Solicitor General appearing for the Union of India submitted that the third respondent is not the concerned ministry, under which the officers of the IAS and IPS cadre would fall, and submitted that the concerned ministry is the Ministry of
the Directorate of Personnel and Training.
Directorate of Personnel and Training, not Ministry.
We will add them as respondent 4, Your Lordship. Let the respondent 3 be there, Your Lordship, but we will add them as respondent 4.
The liberty is granted to the petitioner to implead the said department, the said directorate as the fourth respondent in the petition, and copy shall be served on the concerned department as well as in the what is it called? The Ministry of Law and Justice Branch Secretary.
11 Strand Road. 11 Strand Road.
Branch Secretary of the Ministry of Law and Justice, Kolkata. So, the affidavit shall be filed by the respondents within. Sir, we are closing day after tomorrow. At least from 9th to 18th, nothing will work in West Bengal.
My lords, may I just make two submissions, my lords, at this point?
How much time would you require?
My lords, we need 6 weeks, my lords, because next month, this month that follows in West Bengal, my lords, most of my instructing lawyer friends are also on leave, my lords. So at least 6 weeks.
So it is an appropriate time, madam, for you to come here. Be welcome.
My lords, I always love coming to Calcutta, my lords. I love coming to Calcutta, but I've never invited my lords enough to come to Calcutta.
No. Why is this, sir? I'll ensure that. First,
Mr. Datta, that's
Mr. Banerjee is there. He is immediately extending invitation. Advocate General is there. He will issue VIP passes to you.
No, my lords.
Yes. If my lord the Chief Justice remembers, I had requested your lordship to stay back to Calcutta during this vacation.
I like to stay back, but you are filing so many cases, sir.
But my lords, I must say that your lordship, the Chief Justice, is from my hometown of Chennai, my lords.
Yes.
So
we extend it to Mr. Jetmalani also. Yes, sir.
my lords.
I've been there. In fact, I've been to Calcutta.
I know, we work together. No, Mr. Banerjee will not only send the invitation, he'll send the air ticket also. He can do it.
Yes. My lord, I would request 6 weeks, but your lordships will also see, my lords, that if my lords will hear this matter and are seized of it, then we will file this and hear, my lords. But your lordships will make that decision.
We will give a date on reopening. We let it appear under the same caption to be mentioned. Because the Honorable Supreme Court will deal with this matter on 15th October.
On 15th October.
Yes.
So therefore, on that day also, you can make submissions of. So let's this matter under the same caption on 7th November. And then we decide on the affidavit. 7th November. Then we decide on the affidavit. No.
Yes, so on the 7th of November, my lords, we'll appear before my lords, and your lordships will then indicate, my lords, based on, because the Supreme Court would have
if you can prepare this affidavit, because we are keeping things open. You are raising the issue that the Supreme Court has seized out the matter. Mr. Senior Advocate,
is that if that's the case of Ms. Guruswamy, that the Supreme Court is seized out the matter?
No, I have no case on this, my lords. I am not making any case on
it. It should be recorded. Guruswamy says that.
No, we'll do one thing. Because 15th October, the case is being dealt with by Honorable Supreme Court. Lawyers will be there.
Yes. Mr. Jetmalani will press his case in the Supreme Court. We will.
No, I will point out the court's order.
And by 7th, my lords, if the Supreme Court has taken note of this, and in any case, by 7th, we'll file our reply before my lords.
Yes.
Yes, everything will fall into place, my lords.
Affidavit in opposition to be filed by 7th November.
Grateful.
Well, let it come up. Let them send it. Give it to us 1 week before that.
My lords, we are learning from Mr. Jetmalani, who serves us 20 minutes before
that is not possible. No, we'll list.
I'm not responsible for that. But in any case,
you're right.
You should not emulate bad habits, Ms. Guruswamy.
No, what we'll do is, instead of listing it on 7th, we list it on 14th, giving time for you to file a reply.
Grateful.
Reply, if any, to be filed not later than 13th November 2024. After serving advance copies on the learned advocates for the respondents, list the matter under the same caption on 14th November. Subject to